Let me also give you a few words of warning. Firstly, you probably think I'm going to do much more than I am. My intention here is, as it were, to get to the beginning of our subject and not certainly to get to the end. I am very conscious that I'm among people who know a lot more about the details of intellectual property rights than I do. What I'm talking about here is strictly the abstract philosophical foundations of the subject. And especially, I have to put in a plug for a book at this point. I became aware of a book by Stefan Kinsella, who was the original editor of an online journal called the journal Libertarian Papers. Stefan, as a matter of fact, was the first article in that journal is by me, as a matter of fact. It's also on property rights, a different dimension of them. At any rate, Stefan is the author of a book called Against Intellectual Property Rights. And it's a very, very interesting book, and that's why this paper, because the paper is almost entirely a response to his arguments. How effective is something that you will have to see, and I have corresponded with Stefan quite a bit since the first version of this paper, and we actually don't disagree nearly as much as one might have thought. Nevertheless, we can still call this paper a defense of intellectual property rights. Now, we can only discuss this question by going to theory. There is no way to settle it other than that. We need to know why we should be talking about intellectual property rights at all, and thus we need to know what property rights are, and that's where we start. So firstly, what are property rights in general? Answer: they are normative exclusions of non-owners. That is to say, when somebody is said to be the owner of something, of anything that's capable of being owned, and what that is of course part of the issue here. But whenever somebody is said to own it, what is meant by saying that he owns it is that if anybody else wants to use this in any way that it can be used, he can only do so with A's permission, either explicit or implicit. But the point is, if A doesn't want him to do it, then he's not allowed to do it. So ownership indeed is a right of exclusion. It says nobody else can use this unless I say so. That's a very general definition of property, which applies to all kinds of property, including, by the way, public property. When something's said to be public property, it means that in whatever way they can do it, the public says private persons keep off unless we allow them. Whatever complication that is. But we don't need to talk about public property here, fortunately, at the moment. Now, very, very important is to distinguish at the outset between property, which is a normative concept. It's a matter of obligation, and another thing which I will call possession. This is not idiosyncratic usage with me. I think it fairly well tracks ordinary usage, and certainly it's used, for example, by Rousseau. At any rate, possession is different. You possess something when you in fact have it under your control. Whether you have it under your control legitimately is a logically independent question. When you steal my car, you then come into possession of my car. You certainly don't come into ownership of it, but you do then possess it. Possession, please note, is two-termed. Jones possesses X. Period. Full stop is a meaningful statement. However, Jones owns X, period, full stop, is not a meaningful statement unless you add an explanatory clause. You own something when there's a bunch of other relevant people who are the objects of exclusion. Ownership is not just a relation between you and the thing. It's a relation between you and a bunch of other people in relation to the use of a certain thing. Okay? So now, possession is obviously logically prior to property. We can't talk sensibly about property unless we can talk sensibly about possession. You can't own anything unless you can possess it. All right. Now, nextly, a quick note. I keep saying quick notes, and they never turn out to be really quick, but so it goes. We have to bear in mind sometimes the distinction between moral rights and legal rights. Now, legal rights, we take it, for at least present purposes, are outputs of deliberative bodies such as legislatures, parliaments, etc., which say to all the citizens of some political venue, you may not do this. They forbid various things. Sometimes they require something, but of course when they require you to do something, it means they forbid you to do anything else. So anyway, now those are the outputs of deliberative bodies. They have dates on them. Something can be legal on Monday and illegal on Tuesday because of something that happened in between times. Not moral. Now, moral is, of course, well, it's the subject that I've been pursuing for 50 years in my intellectual life, and it can get a great deal of discussion. But for brief purposes here, when we're talking about morality, firstly I'm talking about what you might call social morality. I'm not talking about individual ways of life. I'm talking about social rules about what everybody may or may not do. And the point is that moral is independent from legal in the sense that it's perfectly possible for legislatures to pass laws that are immoral, and it's been done. Whereas, and on the other hand, morality isn't something that can be legislated. A great deal of discussion can go on about that, but we don't have time. So we'll have to go partly by your intuitions about morality here, but only partly. Because I'm also, in this discussion, leaning on the idea that perhaps there can be a rational morality, a morality for rational people, which is a morality for all people, comma, which can be confirmed by their rationality. We hope that's a project. Some people think it's a project that's not completable. I think most of you probably agree with me, but I'm not sure. But it is the moral foundations of property rights that we are interested in here. So when I talk about property rights, unless it is otherwise specified, I'm talking about the morally recognizable property rights, the property rights we should have, whether or not we actually do have them. And the question before us is, can there be such a thing as intellectual property rights? Okay, well, the next question about property rights is, how do we come by them? Now, there's a lot of discussion about moral theory here, which I'm also omitting, obviously. Speaking of which, I might refer you to some of my books, one of which is this one called You and the State. There's a few copies out there, which goes into these matters a fair bit. At any rate, most of us in the liberal sphere lean more or less heavily on the antecedent work, the seminal work of John Locke, which has been improved on, I think, by Robert Nozick back in 1974 in one of the great books of the 20th century, Anarchy, State, and Utopia. Great fun to read, as well as very interesting and very thought-provoking. At any rate, so how do we go about coming to be the owner of something? Well, there's only sort of two basic options here. One, which is subdivisible into two not very distinguishable parts, is where somebody who already owns the thing in question transfers the ownership to somebody else. One is by giving it away, gift. Well, if I own the thing, it means, now here I'm going to again be kind of high-handed. To own the thing is to be able to do whatever you want with it that's within the limits imposed by other people's rights. They can't stop you from doing whatever you want to do with it, provided that what you want to do with it is not itself antecedently immoral. Gift is easy. If I want to give something to somebody and it's mine, then of course I can do so. Parenthesis, provided of course that he's willing to accept it. It's a rather important provision. And indeed, the willingness to accept the provision ties it to the next, which is much more important than next, exchange. Exchange is where you own something and he owns something else, and either of you, and both of you would rather have what the other guy has than what you have, and you get together and you trade. And so here again, it's a matter of transferring rights that you've already got. There's no problem if it's supposing that the idea of rights makes any sense, which we all think that they do, then transfer of right is a kind of obvious, workable moral concept. However, they both depend upon rights that you've already got. So the question is, how do you come by a right to anything in the first place? There's a categorical name for that, which we owe to Nozick, and in a sense indirectly from Locke, namely original acquisition. So the category is, how does something come to be yours when it didn't antecedently belong either to you or to anybody else? That's what makes it original. So it's the attainment of ownership of rights over things with no prior history of ownership. Here we have two standard methods. And again, they are actually, the ties between them are quite close. The first is where you simply find it. You're wandering along and you pick up something and you start to use it and nobody else has it before. And now, we in the liberal philosophical tradition want to say, yes, you do that and that makes it yours. Rothbard calls it homesteading. I think some other people have, and that term has come to be fairly widely used. Or first occupancy. Now, in the case of land, the natural term is occupancy, because you do occupy land. Other things which you use are not exactly occupied, but you get the idea. First occupancy stands in for, more generally, possession. Now, there are some conditions on first on ownership by first occupancy or homesteading. Of course, by definition, the thing that you come to own cannot previously be owned by anybody. As a footnote, which is a reference to an extremely extensive set of discussions by all sorts of people, initiated by a kind of foolishly thought, an insufficiently thought out idea of Locke's, which is that ownership is a matter of how do individuals come to be the ownership of what was previously owned by mankind in general. He thought that originally things were in the commons, and that there was a matter of common ownership, and we took it out of the commons. There are lots of interesting discussions of this, of which I think mine is probably the best and certainly the most accessible, in which I point out that the idea that God owns the thing first, which is what Locke is in the first place completely unavailable in political discussions. You cannot have moral discussions on religion. That's provable, by the way. There are people who claim to dispute it. I'll be happy to talk with them. I don't think it'll take me more than half an hour to explain why their position is completely untenable. So you cannot appeal to a notion like that in the first place. In the second place, of course, even if you could, how do you know that God gave it to mankind in common? Maybe he was a Jew and just gave it to the Jews, or maybe he was a Nazi, or whatever. Well, at any rate, forget that. So we will assume that prior to the ownership of things by anybody, they are completely unknown. They have no moral status whatsoever. It's just stuff. Somebody comes along, starts using it, and we libertarians want to say that this is enough to give him the right to continued use of the thing. The other method, besides finding, is, of course, making or creation, and that's what we're especially going to be concerned about today. Now, when you make something, of course, sometimes, often, you make it out of something else. And one way for there to be a problem is that what you made it out of actually belonged to somebody else, but you stole from them, and then there would be a problem. So we will just simply specify that we don't have that problem, that the materials out of which you made it either were just found by you and are therefore yours, or somebody gave them to you and are therefore yours. And now the point is that if you make something, then that's another way of its becoming yours. Now please note, it does not logically become yours. It's not logically self-evident, A, that we have any rights at all, or B, that we have this right. By the way, before I pick up discussion of that some more, which we have to, let me here introduce something which has been a pet topic of people who discuss libertarianism for a long time, namely the category of self-ownership. Self-ownership, ownership of me by me, or you by you. Some people have suggested that self-ownership is the basis of property rights. Now I'm going to discuss that idea here because it needs considerable clarification. So, notice that if we do own ourselves, it is certainly by original acquisition. Why? Well, you know, I'm just born with me. By the time I'm a me to be identifiable at all, this body has been mine ever since it came out of my mom's womb. This is as original a kind of possession as you can imagine. But please note that what's necessary and original is possession, not ownership. I possess myself by nature. Now a lot of people say, well, we own ourselves by nature. But that's a way of avoiding a problem, of sweeping a problem under the carpet. Why do I not only possess myself, but own myself? After all, there have been slave societies with lots of people who do not own themselves. Their owners own them. How do we know that the slave societies aren't right and we wrong? That's an important question which we need to answer. That's why people like me write books. Now, whatever, please note that what's called self-ownership is, in fact, a way of asserting the general libertarian principle. The libertarian principle, which is what defines libertarians, is that people may, in general, that people have general fundamental rights to liberty, period. That's their only fundamental general right. And that says, in effect, well, anybody can do anything he pleases so long as it's within the limits imposed by the rights of everybody else. And of course, if you're a libertarian, what you believe is that the rights of everybody else are rights to their liberty, and so on. If to own something is to be able to do what you want to with it, then self-ownership means I can do what I want to with me, which is exactly what the libertarian principle asserts. Now, for this reason, of course, property ownership can't be, in any interesting sense, based on self-ownership. Or at least we need to explain what the relation between these two things is. What relation is there between my owning myself, my being free to do what I want, and my having rights in usable things outside of myself? Okay. Well, so why should we assert the libertarian? Why do we think that libertarianism is right? Why do we think that we do actually have the rights that we libertarians think that we have? Which is a question of the philosophical foundations of morals. My own spin on this, which is in one sense or another pretty widely shared, is that morality is a social contract, an idea that goes back a long, long way, several thousand years. The idea is that the principles of morals are the ones which people, given their endowments of capabilities and interests, and given the impingement on people of other people, other very rational people, the principles of morals are the general principles for the regulations of everybody's behavior, which everybody would agree to rationally, provided that others do so as well. So the idea is that it's the set of rules that all rational beings can agree on. Now, there is quick reasoning behind this, and unfortunately we do have to go through this here before we can get to our subject. So, in the first place, of course, people are motivated by their interests or desires or values For present purposes, we don't need to distinguish between these three things. Philosophical treatises can be devoted to fine-grained distinction between them. We don't need to do that. So we've all got wants. We all want to achieve those wants. Whatever we do in order to try to achieve whatever it is that we want. So we do whatever we can to get the various things that we want. But we are surrounded by people who similarly want various things, and they want different things, and a lot of the things that they want are such that we can't both have them, and that creates a problem. But we note that other people are able to impede our ability to achieve this. Thomas Hobbes depicts a state of nature in which there are no rights whatsoever, and in which people's interest in doing what they want is completely unlimited, and he famously regards that as a perfectly awful condition, and I think he's absolutely correct about this. At any rate, we see that other people around us can impede our ability to achieve this. For example, they can kill us, and that's about as much of an impediment as you can possibly imagine. And of course, we can kill them. Everybody can kill everybody. And it occurred to Hobbes that one obvious thought about the kind of general rule that we need to get out of this, as he thought, awful condition, is a restriction on violence. Let's not allow people to kill each other, or indeed, now, there has, in the last 20, 30 years, been a useful refinement or analysis of this kind of idea, though it is fully, I think, in line with Hobbes' intentions, and that is that what we in general are required to do, morally speaking, everybody, is to refrain from getting what you want, bettering your own situation, by worsening the situation of somebody else. I don't make myself better off by killing you or stealing from you or etc. And so that's the general kind of thing that we want to forbid. So a general recognition of the general right of liberty of all is precisely a universal prohibition on violence, or more generally on what we'll call aggression, which is intervening in other people's lives to their detriment in order to improve our own. There's an important clause at the end of this in Godey's exposition, which I think doesn't materially affect our discussion here, and that is, this is true except when when anything you do will make yourself even worse off, then we've got a problem. Now, so the general recognition of the general right of liberty is general non-harm principle. That's what it is. My being at liberty in relation to you is my not being impeded by you in attempting to live my life or promote my good. All right? And so another way of putting it is that I'm not to attempt to forward my own values by undermining your values. Now, is property justified? That is to say, if we address the subject of the ownership of property outside of ourselves, as I hope to have shown you, the libertarian principle simply is equivalent to an assertion of self-ownership. But what about stuff outside of ourselves? Now, many writers think that there's a problem about justifying these exclusions that property rights consist in. After all, if I have property rights, then it forbids you from doing something that you could possibly have done, namely using this thing which I am using. And their argument is, why should the losers, the propertyless, accept the deprivations that other people's property rights consist in? I'm depriving you of a liberty by having rights. Why should you put up with this, is the question. Now, what rights exclude, let's bear in mind, is nothing more or less than aggressions. That is, what we're forbidding you to do is to use something which, because I'm already using it, and more generally for A to be forbidden to attempt to use the things which B already has, because he already has them. And now, the question before us is, in giving somebody property rights, which forbids these aggressions, Are we imposing a cost on other people? Because if we are, then we are indeed violating their liberty rights, right? That's exactly what we're not allowed to do by the libertarian principle. So it's a very important question whether we impose a real loss on somebody by giving somebody else property rights. Mind you, the somebody else, I mean, you along with everybody else are getting exactly the same fundamental general rights. And so the question is, when we apply this to the acquisition of particular objects and such, is it the case that we thereby impose some kind of special cost on them, which is forbidden by the general principle? And I want to say the answer to that is no. Lots of people think the answer is yes. There's a book edited by Malcolm Murray called Liberty, Gains, and Contracts, which is a bunch of people writing essays on my stuff. And several of them push the claim that right property rights deprive people of liberties and therefore is a problem for libertarians. I want to say no, it doesn't. Now, the first thing to point out is that the excluded, the people who are excluded allegedly, didn't have anything before the exclusion. That is, by hypothesis, either I'm using something that I was the first user of, the first comer, or I'm using something that I created. If it's something that I got there first on, then the people who are excluded are not excluded from something they otherwise would have had. Because if they had had it, they would have owned it, and I'd be excluded. So the point is they're not excluded from anything that they could possibly have been the owner of otherwise. So they didn't have anything before the exclusion, and the point is they still don't have it afterward. Their position is not made worse off by my acquisition of property rights. Their situation in that sense is not worsened. Next, it's an illusion to think that people are excluded from something that they otherwise would have been able to have. In the first place, for any particular material object in the world, it's impossible for more than one person to be the owner of it. Now, a bunch of people can jointly own it, that's true, but then it means they all have to agree on the use of the thing in question. So at most one person can have it. So it's not true that you are excluded from something that otherwise might have been yours, because, as I say, if you had it, then I wouldn't have had it, and it would have been the same story with other variables. So everybody, by definition, is always, quote, excluded from almost everything, always. That's perfectly true. So a moral rule establishing priorities does not exclude you from anything that you otherwise would have had. It only excludes aggression. We do not thereby deny a benefit which everyone else could have. And the second place, in the case where the object is made, you created it, then you are not excluded because the thing in question didn't exist before, because you made it. Prior to that, there was no such thing. Of course, as we all know, as libertarians, other people's ownership of things, in general, rights of ownership of things, enables us to develop and increase the value of those things, and that gives rise to exchange and also to the potential for charity, and these are all both immensely valuable and more so as time goes by. In fact, they make modern life possible. The worst off person in contemporary circumstances is better off than anybody would have been in poverty in state of nature. Okay, with all that behind us, let's move to the subject of intellectual property. Now, we have to begin with a short lecture on metaphysics. It will be short, don't worry, but still, I mean, fairly short. So, intellectual property is not material in a sense. Now, the first thing to say is, we do not need to assert philosophical dualism, which is the view that there are two kinds of things, material and non-material, in order to go forward for this discussion. When we say that universals are not material, we mean something quite specific, which is relatively easy to define, though exactly what the proper philosophical account of it is a very interesting and difficult question, which I do not intend to try to settle here. Universals in the abstract, as we will say, that's a term that's been in use in philosophy. I don't know if philosophers still talk this way, but when I was a boy in graduate school, people had talked this way for a long, long time. Universals, or properties, have the interesting feature that they can be in lots of places at once without division. So, for example, let's take the number 2, which is a universal. Now, there are in the world an infinite number of 2s, of couples, of pairs. 2 flowers, 2 stars, 2 atoms, 2 theories, 2 whatever. And everything that's 2 is 2 in exactly the same sense as everything else is 2. The property of 2-ness, we might say, inheres in all of them, and yet it doesn't diminish. It doesn't have to spread itself out. That's the sense in which ideas in the abstract, or universals, are not particulars, are to be contrasted with particulars. Here are 2 horses, but the 2-ness of the 2 horses is not there along with the horses in such a way that it can't be anywhere else, right? Now, it follows from this that ideas in the Platonic sense, or the abstract sense, are not intrinsically scarce. Indeed, they are atemporal. If an idea makes sense, then it makes sense always and forever and anywhere. There's absolutely no sense in which an idea is bounded by time and place, in the abstract sense, which is what we're talking about here. And that is the main point made by critics of intellectual property, such as Kinsella, who's not alone, by the way. And this is not a dumb criticism, it's a very important criticism. However, there's another sense of the word ideas in which they are not abstract and universal. So let's call this ideas as particulars, and we can also call it ideas in the subjective sense, or ideas that are in the head, as opposed to nowhere. So suppose that Jones, on one fine day, thinks up an idea, as we are all wont to do from time to time. Now when he does, an event is happening that takes place in a particular place in some sense of the word place. I mean, in your head, well, in your mind, whatever that is. But your mind is a particular thing. My mind isn't your mind, isn't your mind. It is not the case. We all have minds, but we don't all have the same mind, right? And an idea can be in your head when it's not in mine, quite obviously. In order for an idea to get into somebody's head, well, what do you know? It's going to have to be either by just finding or creating it, or by transfer from someone else. Those are the only options. Either you tell me about it, or I think it up ab initio. When I think it up, should we say that I have found it or that I have created it? I think that there is not any fundamental difference between these two things here, and I'm not sure how you would distinguish it. I'm sure many of you have had the experience of an idea falling out of the sky into your head. One fine moment, hey, that's it. I mean, it happens. Other times, you grind away at things and somehow the idea emerges from a lengthy process. Maybe we should call the latter creation and the former finding, whatever, it doesn't matter. The point is, processes in your head and not somebody else's lead to the occurrence in your head and nobody else's of this idea. So the point is, we've got 2 radically different senses of the word idea to consider here, namely universals and psychological events, which are particulars. Other people can have exact replicas of my ideas, indeed, but they can't literally have my ideas in sense B, because what defines a particular idea is it's in my head. If you have the same idea in your head, that's fine, but then there are 2 ideas in psychological sense, not one. Mine and yours, right? That's very important. In this second or psychological sense, there can be new ideas, ideas that nobody else thought of before. That is clearly possible. Platonic ideas do not, when we say that they exist in some totally abstract sense, that does not mean that they are, that anybody is aware of them. right? There are undiscovered ideas kicking around out there in the abstract universe, and maybe somebody will discover them someday, and maybe not, and there's an infinite number of those, etc. All right, but the point is, in the abstract, there isn't any such thing as new or old, because ideas are just not in time, they're completely atemporal. But certainly we are temporal. Boy, are we temporal. The older you get, the more obvious it is that we are temporal. And in the particular or psychological sense, clearly there can be new ideas. That's quite obvious. So now, if we go back to our criteria for coming to own something, namely by finding and by making, then it's pretty clear that those categories apply in a quite straightforward sense, or a fairly straightforward sense, to ideas. There is another thing, and it's a subject that's in common to both the ownership of physical objects and also of ideas, if ideas are ownable. If we ask, well, which idea do we have when we have one, we have a problem of definition. What did you actually think up, Mr. Edison? Right? The idea of the phonograph. Well, where does that idea begin and end? When does somebody else have a different invention from the one you had? Obviously an extremely, crucially important question for patent offices, for example, supposing that patents are legitimate. Our ideas can be vague, ill-defined, and confused. Notice that the same is true of anything whatsoever in the case of property. Suppose you come upon a piece of land. How much land have you come upon? Robert Nozick says, well, ask the question, is it just the land that's under the soles of your feet at the time? Or is it something within a radius of 10 feet? Or what? Not an easy question to answer, and of course a question that's often very, very important in practice to answer, and we develop various ways of dealing with problems of that kind. Nevertheless, they are manageable with work. We can get an idea of how to assign pieces of physical property on the basis of finding, even though exactly what has been found is not clear antecedently, but we can clarify it. Okay. And the same is true with ideas. Ideas need definition, and they can get it very often. Now, Kinsella argues, and everybody argues, quite because they're perfectly right about this, that if we're going to talk about ownership, private property, the only things that we can have private property in have to be scarce. David Hume opens his great classic, The Inquiry into the Principles of Morals, his inquiry into the subject of justice, with a thought experiment. 5 minutes are back. Okay. He says, imagine that you live in the Garden of Eden, or better. Anything you want, snap your fingers and you've got it. He said, who would ever think about private property in this country? What would be the use of talking about mine and thine when I can have anything I want no matter what you do, and vice versa? There's no problem of production. And on the other hand, suppose that there is nothing, and nobody can have anything without depriving somebody else of it. We have a total universe, zero-sum game. Civilized social life would then be impossible. And so in either case, the idea of property rights for individuals is hopeless. So you've got to have scarcity, and universals aren't scarce. That's true. However, their discoverers are. There aren't very many Thomas Edisons, and there aren't very many Beethovens, and so on. And very often it is the case that somebody thinks something up that nobody else has thought up, and probably that nobody else would think up. And when that happens, it is not obvious that we shouldn't say that Jones, the discoverer or creator of the idea, shouldn't also be regarded as the owner of the idea. After all, it is possible to steal ideas from people. For example, I can put a gun to your head, and I can say, either tell me or I shoot. Now, that's close enough to saying I have stolen your idea. Or you can write it down on a piece of paper and lock it in your office, and I break into your office and steal it, etc. Or then, of course, in the era of computers, stealing ideas is easier and easier by more and more ingenious people, and so on. Okay. Now, I do want to mention that, well, that first comers are creators. That the distinction between creation and occupancy is one of, it's rather, it's not very interesting or fundamental, really. First comers are creators, and creators are first comers. The man who thinks up an idea first is the first one to encounter this particular idea. All right. Secondly, when we exchange anything, and this is something that could take more minutes than I've got, obviously, to explain at length, but nevertheless, we have to make clear that exchange between two humans is always exchange of services. Now, economists tend to distinguish between goods on the one hand and services on the other. But this is a distinction that's a bit of an illusion and very misleading. When we exchange goods, what do we actually exchange? Answer, we exchange rights. I used to be able to do what I want to do with this thing, and I give you the right to do it. The thing might very well, for example, in the case of a piece of land, stay right where it is, right? It don't have to do any transfer of anything material in the sense of moving it around in order to give it to somebody else. The only thing I can give to him is the right. And that's a service. It's a service to him that he can now use it without impediment, which before he couldn't because it wasn't his, right? We always exchange services, whatever we exchange. Sometimes we exchange services without exchanging what are normally called goods. If I'm an opera singer and I sing you an aria and you pay me $5 for hearing it, then you have given me money for doing something for you, but I haven't given you anything physical. You can't walk off. Of course, I could sell you a CD, but that would be a separate operation. Okay? So I can impart my ideas to you, and if I don't, then you don't have them. And in that sense, ideas are, as I put it, scarce. And so being scarce, they are now, it seems to me, in the category of that which can be ownable. And Kinsella reluctantly actually does agree with this. He says that intellectual property rights impose an artificial scarcity. And that can be true, but it shouldn't. And that's where the fun begins. And unfortunately, where this discussion will also have to end. We're ending, as it were, at the beginning. I think it's pretty clear that people, A, can legitimately, coherently, reasonably be thought to be capable of being the owners of intellectual things. And furthermore, it seems to me that they ought to be so regarded by libertarians. The question is, where do we go from here? Because if I give you an idea, you of course can transfer it to somebody else, or indeed, so you can put it on your computer and now everybody in the whole world can know about it, and that's very easy to do, and we now have a problem. So the question is, what do we do about it? And, why do we do it and how much do we do? That's an interesting question. Now, I agree, I think Kinsella and I agree on the following thing. I can impose on you a condition for having I tell you my idea provided you don't tell it to anybody else, right? I give it to you for a certain amount of money and I say you cannot transfer it to somebody else for free or otherwise without my permission. That is perfectly possible. What's difficult, of course, especially after the first couple of go-rounds, is how do you enforce this? Enforcement is a very difficult matter when it comes, especially in contemporary times, to ideas. What do we do about that? Well, I had a couple of very, very little minor suggestions about that, but I do want to say just one thing that I think is very important here. Since when I give you an idea, what I have given you is access to something which is actually universal. It follows that when I'm the creator or initiator of some idea, I'm not necessarily the only one who does it. Somebody on the other side of the world might have thought of the same thing at the same time. Or somebody next door might think of it later, even though he doesn't get it from me. Perfectly possible. There can be N originators of an idea, and not just one. So, if we give Jones a property right in this idea, what does it do to Smith, who also thought it up? And I want to agree with Kinsella that it's wrong for us to prevent Jones from using his idea just because he thought of it later than Smith. As long as he actually thought of it and didn't get it literally from Smith, he should have as much right into this Smith patent in his, no more and no less. So, and that's a very important point because patents and property rights both, I mean intellectual property rights, tend to be construed, as Kinsella correctly observes, as if they can block legally the creation of ideas by other people. And this is wrong on the libertarian view. I agree with that. So we have a problem here, which I do not have a full solution to. One part of the suggestion, though, is this. Suppose I think of it, and the next person who would have thought of it thinks of it 20 years later. A plausible suggestion would be, well, you've got a right from now until then, and not beyond that time. This sounds slightly fanciful, but in the contemporary technological era, I think a lot of you people are probably geeks. I'm not. But geeks will know that you think up something in the area of, say, software design and so forth, and somebody else finds out that you've done it, and whether or not, and without copying yours, he's going to think up something that does the same thing pretty soon. The time during which you have exclusive rights over this and it does you any good is very short nowadays. I think that's true and very important. Exactly what implications it has is a very interesting question, and the man who's speaking next, I think, is going to address some of these issues in a way that I'll find very interesting here. So that's as far as I've gotten, which I'm sorry if you don't think it's very far, but I hope you will agree that it's somewhere. Okay.